There have been a number of statements this week that may have rubbed people the wrong way. Here is what Governor Oparanya had to say following the arrest of Governor Waititu. He said the way Waititu was arrested and frog-marched was inhumane, especially for a man of his stature. He said you could easily have summoned the governor, told him what you wanted instead of searching his house in the manner in which it was done, talked about the drama before the media and said that their dignity and their human rights should be upheld as is guaranteed in the Constitution. Essentially, the governors are demanding for what they call an honorable arrest. So, is it special treatment they're seeking? The EACC says yes it is, and they're not going to grant that to them. But tonight it got me thinking that perhaps we need to take a look again at what the rights are of an arrested person, and then you be the judge. Remember, this is information that could really help you. Now, they're talking of dignity. The governors, well, they are absolutely right. Article 28 talks about every person having the inherent dignity and a right to have that dignity respected and protected. This article refers to every Kenyan, regardless of stature in society. And the word dignity comes up not just here, but in a number of places in the 2010 Constitution. So this is something that should be held even during the process of an arrest. But when speaking about the specific issues of governing an arrest, it's all done in Article 49. That is what outlines your rights or the rights of an arrested person. Now, the first thing it states is that you have the right to be informed promptly in a language that you understand. Number one, the reason for your arrest. But now, even before this happens, let me tell you what the UN Basic Rights Standard for Law Enforcement Officers says. It says that the officer has a duty to introduce himself or herself even if they're wearing uniform. Once they do that, they inform you of the reason of your arrest. And then, just like we see in the movies, I know they talk about the Miranda rights in the US, it is indeed the same case here. You have the right to remain silent. And this is something that we talk about in the Miranda rights. It looks very fashionable abroad, but it is actually guided in our Constitution according to Article 49. You also have the right to be told the consequences of not remaining silent. As in, anything you say can and will be used against you in a court of law. You also, at this point, it's important to state, have the right to communicate with an advocate or any other person whose assistance you may deem necessary at this time. And you are also supposed to be not to be compelled to make any confession or admission that could be used in evidence against the person. That is the right, the consequences of not remaining silent. Now, here is a sticky issue because this is also something to do with what we like to call in the country Kamata Fridays. Now, you are supposed to be brought before a court as soon as is reasonably possible, but not later than 24 hours. Now, let me take you a little bit back to those UN Basic Human Rights Standards for law enforcement officers, because it even goes on to talk about the nature and the manner of arrest and the amount of force that can be used in effecting an arrest. It's supposed to be minimal force. So an officer should come to you, inform you of the reason for your arrest, inform you of your right to remain silent, and handcuffs aren't always necessary unless a person is resisting arrest. If you take a look at the case of what happened with Governor Waititu, he was ushered into a van, which is more than can be said for most people who are bundled into the back of a Land Rover, and you know how it's done. They hold you by the waist, all right? So they are supposed to then enable you to accompany you to the police station. Now, here is the interesting thing. If you are charged with a misdemeanor, which is those minor crimes like being drunk and disorderly, for example, and this is an offense that would attract no more than 4 years, then there is not necessarily a need to arrest you, but you can be given a police bond and asked to appear at the police station or at a court of law. If it is a serious offense, one that attracts a sentence of more than 7 years, like murder, at this point, then you could be arrested. Now, here's another thing that you need to know. You cannot be arrested to assist police with investigations. Because remember, you have the right to remain silent. Anything you can say will be used against you. So you can only be summoned for questioning, as we have seen happening with some cabinet secretaries. Here is another important question to answer here, because the governors are complaining about being embarrassed during the process of an arrest. I spoke to legal minds in this country. Is embarrassment justification in law? They tell me not necessarily. You see, embarrassment is subjective. For example, if I got arrested and I was touting that I am an important person in society, that is subjective because that's according to me, right? You may disagree with how important I think I am in society. So when you violate the law, or when you are suspected of having violated the law, you get inconvenienced by the process of arrest, and that can sometimes happen in the full glare of the media. The use of force is something that should be used with restraint. For example, if it is a woman or a person with disability jerking their hands backwards, whipping out your gun, using handcuffs may be deemed something that may not necessarily be important in terms of use of force. With all of this, are the governors then justified in their calls for an honorable arrest? Do you think their rights have been violated? Have they been embarrassed? Have they lost their dignity? You be the judge from that explainer. And hopefully it also helps you when you get into a sticky situation. That's our explainer.